Hi, my name is Natalia and I'm a real estate attorney here in the state of Florida. And today I wanted to talk to you about settlement agreements in divorces and what happens when those involve real estate. So there are 5 things that you should really focus on having in these settlement agreements. Number 1, you've got to make sure that all real property is listed in the divorce decree. There are so many searches that I have conducted in which the final judgment of dissolution, the settlement agreement, failed to include a number of properties that were acquired through the divorce or that were used by the husband or the wife during the marriage and therefore are marital property. Number 2, it's not enough that the property is titled in just one spouse or the other during the marriage, and therefore you think that that disposes of the issue and leaves the same people in title. No. If you acquired or used a piece of real estate during the marriage, it is irrelevant that it's only titled in the wife's name or only titled in the husband's name. What matters is the use. So if you, for example, had a rental property and you use that rental income as marital funds, you commingled it with how you paid your mortgage, your rent, etc. of your primary residence, or you used it to spend your vacations with your spouse and kids, that's probably going to be considered a marital asset. And so you're going to need disclaimers from your former spouse included in that final judgment to ensure that that property is not going to create an issue later on when you're trying to sell it and you don't have anything from that former spouse where they quit claim their interest out of it. So please make sure that's addressed. Number 3, failure to assign ownership creates a tenancy in common. So if you've acquired property as husband and wife in your time of marriage, and then you get a divorce and you fail to include that property in a distribution, who keeps what, and you fail to do the title transfers, well, now you own that property with that other person, your ex-spouse, as tenants in common, which means if they die, you are now dealing with their heirs, who may not just be your children. And the same goes back and forth. So please be aware of a tenancy in common. They can also convey their 50% interest to whomever, and then you're dealing with complete strangers. They can also devise it so they can put in their will who they want that other half to go to. Be very careful about not omitting this and not forgetting that you will have a tenancy in common in place. Number 4, be really clear about refinancing mortgages. Put a timeline. What amount of money is supposed to go to the other spouse? Seriously, how long do they have to refinance? Under what terms are they going to refinance? Is there an alternative if they're unable to refinance during the time period? Please be clear. And then number 5, have an in case of death clause. We live in the state of Florida. Strange things happen. People pass away with regular frequency. We can't escape death or taxes. And so you must put in your settlement agreements what happens, especially if you have an activity, an action that needs to be done after the final judgment of dissolution. What happens in the event that that person dies or the other person dies? Who gets what? Does the property go to A or does it go to B? All of those things should be included in your agreement. So please keep those very important 5 items in mind, and good luck out there, investors.